I really don't think I faced any obstacles as a result of being a woman, or at least not that I was aware of, because I've had this peculiar trajectory of actually making my own environment all the time. What I do remember is every now and then having quite difficult things said to me by opponents who didn't like dealing with a woman, who didn't like being bested by a woman, perhaps. But I've had other sexist things said to me, you know, or rather the most remarkable, I think, was said to one of my clients as I was he was being interviewed. He was a refugee. He was a political refugee, and he was being grilled for hours on end by immigration officers. And we had a break, and I went out. And when I came back, my client was very upset. And I said, "What's happened?" He said, "Something terrible happened." And I said, "What was that?" And he said, "They said something terrible about you." And I said, "Oh, what was that?" And he said, "I heard this man say, 'She's a hard bitch. Look out for her, she's a hard bitch.'" And of course he thought I'd be upset by this, but I was delighted. Martin Day was happy to join me, which was a bit mad of him because they were just about to make him a partner. And so we found an office and moved in and started a new firm. And our intention in starting a new firm was to work quietly on our own cases, not do any administration, not have to employ anybody, look after our clients, and have not a fairly hard-working life, but focused on our cases. And within a few years, the firm was just expanding by leaps and bounds as a result of things we hadn't foreseen at all. So now it's got about 400 members, this firm. We worked very well together, although he's much younger than me. Martin did the large multi-party cases. It didn't start out like that, but he got involved in an action against the operators of Sellafield for childhood cancers. So he did the big cases, what you might call, well, a lot of them are what you might call toxic torts. They were cases against companies running dangerous things. Well, I think in earlier years, I focused very much on my work to the exclusion of really almost anything else. Later, from 1987 onwards, I've been responsible for the care of my sister, who's severely learning disabled, and prone to getting very ill at very regular intervals. So managing her care and being with her whenever she injured herself was a huge strain. So although I haven't had children of my own, which made my earlier years, I'm sure, much easier, I was able to focus on work without the stresses and strains which I saw in other women's lives. I think one of the most useful things I did was entirely due to my sister, who's severely learning disabled now. But when she was about 30, somebody took out all her teeth without any consultation with us, without any warning. So she woke up without teeth. And of course we complained, but it got us nowhere. And I discovered eventually that what had happened was that there was no mechanism for making decisions about medical treatment on behalf of people who had no capacity to make the decisions themselves. So when a mother came to me about her daughter who needed to have a sterilisation operation, which was not therapeutic but regarded as sort of social, because she was having unprotected sex and couldn't take the pill anymore, I really got the bit between my teeth, and I decided that I was going to prevent her getting pregnant and having a delivery, because the delay in getting any kind of decision would have meant probably that she would have been sort of, I don't know, 7 or 8 months pregnant by the time. So I managed to get this into the House of Lords in 3 months. I had a week at first instance, or was it 2 weeks? A week in the Court of Appeal and 2 weeks in the House of Lords. I must say, when they started to talk about the court of lunacy in the 1890s, on the last afternoon, I thought I'd lose the will to live. But anyway, after that came this decision, which is called Re F, and which really did change the law, because it exposed the fact that you needed to have some law to decide how to make these decisions, and it was decided that you should have proper procedures to find out what was necessary for the patient. And later on, this became the Mental Capacity Act of 2005. So I think I can say I sort of did that with my little hatchet. I got involved in the Woolf Inquiry as a result of getting very angry about something, which I have done periodically during my practicing life. And in this case, it was the dreadful way in which huge medical negligence cases would plough on towards trial when they should have been settled. And in 1994, I was in a complete rage by about March, because I'd had 3 cases which should have settled roll on to the day of trial, or practically the day of trial. You've got not only the experts on the question of whether there's liability, whether someone's been negligent, but then you've got to prove what the effect of the negligence was, so you've got to prove that the negligence caused the damage. And then you've got the massive work of quantifying the future life of a catastrophically injured person. And many of my clients were children who were so badly injured they couldn't wipe their own faces, couldn't recognise their parents. Dreadful, dreadful injuries. So that's a huge amount of work and a huge amount of people. You've got to plan into a plan for a trial. And massive amounts of paper, whole taxis full of paper in those days. And altogether terrible waste. So I would get very, very angry. And then suddenly appeared the Civil Justice Inquiry, the Access to Justice Inquiry, run by Lord Woolf, whom I dealt with when he was Junior Treasury Counsel, long before he was on the other side of my immigration cases. So I knew him to be a thoroughly effective, and I might even say ruthless person. So I thought he was what it needed, and so it proved. So I gave up my practice, handed over my cases to assistants and colleagues, went off, effectively off salary for 8 months, and it was really, I think, quite effective, because we worked out all sorts of solutions to medical negligence litigation, which meant that cases didn't roll on to trial without being settled. I was given an OBE. I've never quite known what to do with it. And I was asked by the Department of Health. They said, you know, we must get you a gong. And I went, no, no, please don't. In the end, I think it was probably Lord Woolf and the Lord Chancellor's Department decided I ought to have some reward for the Woolf Inquiry. I was pretty annoyed when I got there and found the Queen wasn't there. I should have found out, but I got there and in my matching suit, hat and so forth, what a sweat. And this chap said, today your investiture will be taken by the Prince of Wales. I was really annoyed, really gutted. But the Prince of Wales was quite charming anyway. But I did rather fancy seeing my sovereign. There we are.